Applicant number 2, Celco Partnership, doing business as Verizon Wireless.
Unique circumstances. If I could direct your attention again to presentation. Our next applicant is Celco Partnership, doing business as Verizon Wireless. Again, they're requesting a use permit for a telecommunication monopine tower. The area of this subject application is within the Puna district. More specifically, we're looking near the Pohoa area, which is located on the right bottom portion of your map. Just for reference, going through the middle of the map, we have the Keao Pohoa Road, which is Highway 130. Again, for reference, this particular area here represents Ainaloa subdivision. On the blue color, smaller lots represents Orchid Land subdivision. On the upper portion of the map is the Hawaiian Paradise Park subdivision, for reference. The subject property is located within the Tiki Gardens subdivision. Right now you just see a little small black dot, but we'll zoom in there. Again, for reference, we have Ainaloa Boulevard moving in through the middle of the map. On the bottom portion of the map, this is considered Ainaloa subdivision, and across the street you have Tiki Gardens subdivision. Again, the subject property is located within the Tiki Gardens subdivision. It is accessed from Silver Sword Court from Ainaloa Boulevard. The subject property is identified with a black outline and is zoned agricultural 1 acre. It is a smaller lot. It is 8,100 square feet in size. The applicant is requesting a use permit to construct a 105-foot tall steel telecommunication monopine with 8-foot tall panel antennas and related facilities on an 8,100 square foot parcel. This is situated within the State Land Use Agricultural District as well as the county's agricultural 1 acre district. The applicant's objective for this site is to provide infrastructure necessary for wireless coverage to the residents and guests of the Ainaloa subdivision and the surrounding neighborhoods. The property is centrally located between 2 existing Verizon Wireless sites, one being located at Bryson Cinder in Pohoa Village and the other located on Pohaku Circle in Orchid Land Estates. This is located on the Sure Foundation Church site along the highway. This is the applicant's site plan. Just for reference, on your right side would be Silver Court Road, so access would be from the right side of the map. The actual location of the tower with the facilities will be located near the rear portion of the lot. For this particular tower being 105 feet in size, the setback ratio for a freestanding tower is 1 foot for every 5 foot for a freestanding tower. So being 105 feet in size, the setbacks would be 21 feet from any boundary line. According to the site plan, it appears to meet those setbacks. This is an elevation of what the tower should look like. Again, this is a unique tower that they try to minimize visual impacts by creating what they call a monopine. This is kind of what it looks like, this right here. This one is a shorter one, but it kind of gives you an idea of what they look like. This is an aerial photo. Again, for reference, we have the Ainaloa Boulevard on the lower portion of the map with Silver Sword Court Road. The subject property is in this general location, currently undeveloped. And as you'll notice, around the subject property is undeveloped lots. The nearest house is in this general location here. These are site photos. Do you have any questions regarding? The site, this is a photo on Ainaloa Boulevard looking Malka. The access to Silver Court would be on your right side. This is looking Mackay with Silver Court on Ainaloa Boulevard with Silver Court on your left side. And then this is on Ainaloa Boulevard looking directly on Silver Court. So you'll notice that it is an unimproved road. The actual area is just before those trees in that general location. The planning director is recommending that the planning commission approve this request with conditions. I do have a few bits of information I need to bring to the commission's attention regarding this application. We have received several letters since the background and recommendation was submitted to the planning commission. One is a letter dated January 31st, 2014 from Dane and Sherry Shinsato. This is an opposition letter that you should have all received. And we've also received a comment letter from the Department of Public Works dated February 3rd, 2014. There is one correction I need to make on the record. Unfortunately, sometimes we cut and paste and we miss something. This would be on page 4 of the recommendation in the second paragraph. 1, 2, 3, 4, line number 5. It says the tower site is located on a small portion of a 5.371 acre property. If that line can be deleted. The property is 8,100 square feet, which is identified at the lower portion of the page. And then lastly, the planning department has received a petition for standing in a contested case from Daryl Nava. This was received on February 28th, Friday. There is a question whether or not the request is considered timely. In our Planning Commission rules, Rule 4-6A, it says that the petition needs to be submitted before 7 days before the Planning Commission's first hearing on the matter. So when we look at it being submitted on Friday, we'll count Friday, Saturday, Sunday, Monday, Tuesday, Wednesday, Thursday. The date of the hearing would be the 7th day. So it's going to be up to the discretion of the Planning Commission to consider standing in this regards. They did submit the $200 filing fee. So other than that, everything's in order with the petition. With that, that concludes our presentation. Are there any questions?
Questions for staff?
Thank you.
Thanks, sir. If I could call up the applicant, please.
Good morning.
Can you raise your right hand, please?
Yes.
You swear to tell the truth before the Windward Planning Commission today?
Yes, I do.
Thank you. Go ahead.
My name is Danette Martin. I work as a consultant for Verizon Wireless, and I was tasked with trying to locate this tower. And I realized from the comments that people, that you've made with the previous application, that there's some concern about the siting for this one. And I wanted to answer your question more directly on how far do these towers really go. Well, when we first started, back in the analog days, they went 20 miles. And then we came up with the, PCS, and those would go 5 miles in circumference. And now with the new wireless broadband, they only go 1 mile. So that's the really difficult part in trying to site these things, is that you've got an existing coverage area here, and you've got, we kind of laugh when the RF engineer gives us the specifications, because they used to be called search rings, now we call them search dots, because they're so small. So when I first got this search ring for this Ainaloa's area, I was told that the Ainaloa Community Association had a pole, there, a flagpole, and that would have been the perfect thing to co-locate on. That's the first thing that we do, is try to co-locate on existing structures. But the RF engineer said, no, that's too far away. So don't even consider that one. So we went, I first went to Ainaloa Community Association. I tried to start with the community first in our siding, and they referred me to some areas in their subdivision. They have, I don't know, if we could go back to maybe the map, you'd see that there are large squares where it would indicate that maybe there are larger parcels there. Well, those are set aside by the homeowners association, or the developer for the homeowners association, for future parks. And so they thought, well, that would be perfect. Why don't we put it someplace there? Because we really, really need the service. So we tried that, and we actually got the go-ahead from Verizon Wireless to do that. I pulled the title report, and I see that there is a restriction on that parcel, that they can't, that this company paid Ainaloa Community Association a sum of money to purchase the rights for telecommunication on that tower that's at their community center. What they didn't realize is that they were also signing away rights to all their other property. So when we went to them, they said, well, you know, we're going to charge you, you know, we'll let you do it, but we're going to charge you this huge amount of money. Went back to Verizon Wireless, and they said, that's extortion. No, we can't do that. So I looked around, I called all the large property owners in the area. I tried to get in touch with them. Some I could not get in touch with, but I did try. And so that left me tasked with just trying to find something with what was existing. And so if you look back on that tax map, you'll see that there are miles and miles of small lots. So if we're not able to place it on a small lot, these people won't get the coverage that they need.
Any questions for the applicant? Mr. Otto?
Yes, over the years, when these requests came in, I was looking at the distance and single pole. But if you're saying a 1 mile distance between pole A and pole B.
Right. Oh, no, I'm saying a circumference, so figure 2 miles maybe. Because you've got 1 mile from this way and 1 mile from that way.
Okay. Oh, I see what you're saying.
Yeah.
I guess every request that came in had the objection of the so-called radiations, whatever, right?
Oh,
And,
safety.
yeah, I'm just wondering in terms of distance then.
Yeah.
It seems to be more concentrated when you say a 2 mile distance between, I don't know.
Although it's not something that typically you guys deal with, but I did bring some information that the FCC puts out. And in plain language, it explains that you have to stand in front of the antenna within 2 feet for a prolonged period of time to have any negative effects, yes. So if you'd like, just for your information, I brought it. And I thought maybe, you know, if there was some of the residents here that were worried about that, I could set their mind at rest by providing this information.
Thank you. Any other questions for the applicant? Thank you, Ms. Martin. And I think at this time we're going to address this, consider the standing on this contested case hearing. So if I could ask Mr. Nava to come up, and the planning director and or his attorney. Who's first?
Windward Deputy Corporation Counsel, attorney for planning director, Dwayne Kanuha, and the planning department.
Actually, can I get you to swear you up? Could you raise your right hand? You swear to tell the truth for the Windward Planning Commission today? Thank you.
I'm Ainaloa. We own the lots, 2 lots right across the street, parcels 97, 98. And I guess I represent myself, my wife, and my son.
I'm not sure where I'm going with this. Mr. Nava, would you consider this one day late, or are you saying the 7 days, this is day 7?
You know, it's late. I misinterpreted, the language on when you have to file it by. So it is my fault. And Jeff Darrow has been helping me with this process. And he's been very helpful. And I called him late, and it is my fault that it is late, and I recognize that. I did want to say though that I did submit a letter myself, which wasn't recognized this morning. I dropped off a letter on behalf of myself and my wife to the corner office, which seems like the planning department didn't get it.
If I could address that, Mr. Chairman. The letters that he's referring to were made part of the background, so they were submitted in Washington.
Well, again, William Berhunty, before we have this dialogue and consideration, why don't I place my objection on the record, and then we can make a determination regarding my objection. So the county employee, the planning department hereby objects to Mr. Inava's request to intervene pursuant to Rule 4.6a. Motions to intervene or request to intervene should be provided 7 days prior to the setting of this hearing. And in this case, the record will reflect that the request to intervene was filed only 6 days prior to. So therefore, the county puts its objection on the record that Mr. Inava's motion to intervene shall be denied. And that being said, I've known in the past, our objections, again, are to protect the record in case this matter goes up to appeal, and therefore I'm placing it on the record.
Thank you. Well, they'd like to ask you if you have a response, but you kind of already told us, it's like, accept your responsibility for that. Is there anything else you'd like to say in response to Mr. Berhunty?
Nothing really chance.
Sorry. I'm not sure. I think maybe I'm going to direct this at you. Is there a precedence here? Are these things sometimes allowed when they're late, never allowed when they're late, always allowed when they're late?
Unfortunately, I'm not. I'm not really sure about any precedent set. I just the authority for granting standing comes from the commission. So.
Well, it's clearly Mr. Berhunty's stated Rule 4-6A. It is like, how do I proceed, Darren? Do we need a motion?
Yes, you will need a motion to either grant or deny standing, and you need to specify exactly why standing is not being granted or being granted one way or the other. Just for the record, we should note that there has been precedent where someone has filed a request for intervention late and the commission did grant standing based on circumstances, and I believe that was Jeff Gomes, if I remember correctly, with the connections case. And all right, and anyway, but so there has been precedent. Just wanted to make that clear.
Commissioners, questions?
Mr. Norbert, give me your side of the story. Let me hear what your position is.
Just on, are you being late? Or?
No, not on the lateness. We know already we're late. Why are we filing this contested case? What is your position?
I filed it because I just wanted to make sure my voice was heard in this whole process. Jeff has been very helpful to me, trying to explain things going along. One thing I was a little disappointed with, I sent a letter to Ms. Martin just asking about information on the effort she's made to maybe cite it somewhere else. And I felt like I gave them the benefit of the doubt to provide that information to me. And that's kind of why I waited so long to do anything, because I was waiting for a response from her. I didn't get anything, and when I called Jeff, I wanted to find out, okay, what exactly is the process? And he told me, okay, if it comes up, you'll get 3 minutes to speak. And I kind of was shocked that, wow, it really affects my family, and I'm only going to have 3 minutes to speak. So I asked him, what other things can I do? And he said, you can file the petition to be an intervener, which, I didn't really want to do because I know it takes up a lot of time, expense, everything for the county. But, if this whole process can go on, I wrote a courteous letter to her. I never even got a response. I thought I have to do something to at least voice my concerns as best I could. I didn't think it could be done in 3 minutes. So that's why I filed it. And, the day I called in to find out everything, it was the 7th day or the 6th day, as you say. I filed it right that day, paid the money and everything, but it was late. I read that section before. The way I interpreted it, I thought that was the 7th day. I thought I was going to get it in on time, so I called him. So the error is all in my part. As far as the whole picture, my family, me and my wife own 2 lots, and then the other person they mentioned is also my family. It's my sister and her husband. They own 2 next door, and we're right across the street, directly across the street. And based on looking at their design, the lot's all been cleared already, and it looks like they're gonna have a driveway straight to the tower. There's nothing gonna be blocking the view of the tower from our lot, and completely in the view. And the right-of-way is only 40 feet, so it's right there, right across the street. And I have a son that's 7 years old. I don't plan on selling the property. I think later I want to give it to him, and if I don't file that action just so my voice would be heard, it would just go through, and he would be heard later. When he gets old, if he wanted to sell it or if he wanted to build on it, he would be affected. So I just thought I had to do it, just so my voice was heard and you could listen to the concerns that I had, because I think they're very valid. So that's where
Which is, what is those?
kind of just go over everything I was. So did you guys get that letter?
Yes.
So there's no sense of me going over the letter again because you've all read that, right? It wouldn't have any more effect. But just on their application itself, I can just go over what, was kind of discouraging to me. On page 3 of the application, right at the top, it says, no cultural materials of any kind were observed during the archaeological inspection. I went and read further on into this document, which references an Exhibit C, and that's a historical property assessment by T.S. Dye and colleagues, archaeologists, Inc. In the introduction, it says the primary focus of the project was on the discovery and appropriate treatment of historic properties within the area of potential effect. The goals of the investigation were to determine whether the installation of the telecommunications facility, including an antenna monopine, will have direct or visual effects on historic properties. And on page 4 of Exhibit C, on the background research, it says no field inspection of the proposed site was conducted by T.S. Dye and colleagues, archaeologists. So they haven't even been on site. And it didn't seem right that they're using this report prepared by a professional and they've never even been on site. So I kept reading, and again on page 9, it reiterates that no field inspection was conducted by T.S. Dye and colleagues, archaeologists. And it says no permits for the subject property are found to indicate that any grubbing or grading has occurred on the parcel. I don't know who this is, but Bureau Veritas North America interviewed the real estate broker for the current owner, who indicated that the subject property has never been developed and has never been used as agricultural land. But if you go back to the application, page 3, it says, according to the property owner's realtor, Hank Pereira, the property was recently grubbed. So I'm going back and forth in this document, and they're saying one thing here, and they're saying the complete opposite in other areas. So, I was just concerned about that, and the exhibit goes on to say, A review of the archaeological literature, historic maps, and information provided by Bureau Veritas North America shows that the project site is unmodified and lava tube caves may be present. Caves may contain cultural resources. Based on this situation, it is recommended that an inspection by a qualified archaeologist be conducted for the entire parcel. And I'm thinking, this guy is supposed to be a qualified archaeologist. That's the title of his company. So it just wasn't making sense to me. So I kept, looking into it more with Jeff's help, and came up with a couple other things. Something very similar. I guess a special use permit application went through regarding a property in Orchidline Estates, and that was denied in March 2006. And I feel like our situation is worse than that particular case, because over there, they were dealing with 2-acre parcels. The right-of-way was 60 feet, and one of the owners, I believe his name is Mr. Pa, he was 200 feet away, and he was allowed to intervene, and his voice was heard in that matter. And that application was denied, although it was determined unusual, it was determined not reasonable for that Chapter 205-6 purposes. And they cited adverse effects on property values, adverse effects on the views that include whoever can see the tower, and the fact that the cell company didn't thoroughly do as much as they could to investigate alternate sites that may be viable for them. There were other options that are still out there, and they didn't exhaust all of those. So I think my situation is very similar. They were working off of a 2-acre parcel. These are 8,100 square foot parcels in the area they're trying to build this tower. The right-of-way is 40 feet. That's a third less. So I'm actually, only 40 feet away from the parcel that they're going to build a 100-foot tower. I live in Waimea. In the subdivision I live on, the lots are 75 to 10,000 square feet. And it's almost unimaginable to have a 105-foot tower located in any of those lots with all the houses that are built out. It's unbelievable just to imagine it. So I researched further. Again, I came up with a hearing transcript from, I believe it's February 3rd, 2006. Am I allowed to read from that? Is that okay?
Mr. Chair, I think we're permitting him to state his case, and we haven't decided whether we're going to hear it or not. So I'm kind of questioning the procedure at this point.
All right, well, I have to ask Mr. Ishibashi if he's still interested in what he has to say. It was his question.
Well, that was my reason for asking the question. I wanted to determine his position before I make a ruling or make a decision on what he, timely filing of this case. The problem I had was exactly what he's talking about in regards to the archaeology report that came back. Because how can we accept in a report there was no physical inspection?
Chair, Mr. Chair, I'm going to raise an objection. We seem to be deliberating the actual points of the motion to intervene at this point. I'm going to request that we just go back and we readdress the issue as to whether or not we're going to assert standing.
Okay, very good. Mr. Ankle, I know you had a question.
I have a question that refers to the standing. Mr. Inaba, your neighbor that owns a lot across the street, is he a resident of the area?
The person
that's leasing the lot to Verizon?
he's actually selling the lot. And my understanding, he's selling 3 lots surrounding it as
But he
well.
doesn't live in the
I don't
neighborhood?
believe so, no.
So
She told me he
I
was
would
in the
think
middle.
this impacts you a lot more than even him. And I would be inclined to think that Mr. Inaba has standing, and since there's been precedence of a late submission in the past.
All right, let's
Mr. Chair, I'm sorry, I have one more question. Before I make that. Mr. Inaba, have you ever faced a committee like this previously?
No, and I'm pretty petrified
Is
right
this
now.
your- Well, you're rather articulate. I'm trying to, I thought maybe you had some
I
experience.
mean, I feel like I'm in a David and Goliath situation, but. I
You've
mean,
never had
it's
that
a-
experience?
No, sir,
Okay,
no.
thank you.
not at all. We're all here to work together. I understand you're a county employee.
Yes, that was my time.
For the record, could I just get you to state that you're appearing here on your own time?
Absolutely. I work for the Department of Finance, but I'm taking vacation time.
Very good, thank you. I think we should go ahead and entertain a motion then, on whether we want to grant standing for a contested case or not.
Quick question. To clarify, for Corp Counsel, if we grant standing for a contested case, does that mean that we stop deliberation on this item until it's gone to?
I think we would continue it for the next meeting.
Sorry, Margaret Mastanaga, Deputy Corporation Counsel, and under Rule 4-6, it does state the relevant part about standing, you know, if it's timely filed, and then the criteria on whether it can be met, whether Mr. Inaba's interest is clearly distinguishable from that of the general public, or government agencies whose jurisdiction includes the land involved in the subject request, or that they have some property interest in the land or lawfully resides on the land, or that even though they do not have an interest different from the general public generally, that the proposed action will cause them actual or threatened injury in fact, or persons who are descendants of native Hawaiians who inhabited the Hawaiian Islands prior to 1778, who practice those rights which were customarily and traditionally exercised for subsistence or for cultural or religious purposes. So that's generally the criteria, okay?
Thank you.
Okay. Mr. Garrett.
Thank you, Mr. Chairman. The other question that may be posed to the commission is whether or not the commission wants to hear the contested case or whether or not they want to hire a hearings officer.
Okay, so first we need to decide whether or not we're going to grant it, and then if we decide yes, then we'll address that. Okay, back to looking for a motion.
Mr. Chairman,
Yes, sir.
I'd like to move that in the use permit application 14-000046, Verizon Wireless monopole, that we grant contested case status to Daryl Ainaloa.
Second.
Any discussion, commissioners?
Yes, could you clarify that? I'm sorry, I don't understand the motion.
I believe Mr. Commissioner Hinkle is asking to approve his
Stand.
standing for
Even though it's
contested
today.
case here.
So that you could present it today, or is this?
No, we'll have to come back.
Thank you.
Any other discussion?
I have a clarification to request. If we could identify the criteria that we are granting standing for, as Margaret Matsunaga had stated, if we could identify the criteria.
His criteria that his interest is clearly distinguishable from that of the general public, that they have property interest in the land they lawfully reside on. Are you one? Yeah, that meets two of the requirements.
Thank you.
You second. Is that Mr. Ichiban? Ms. Martin, do you want to respond to any of this before we vote?
Well, first of all, I want to apologize. I did not return a response to his letter, and my daughter's been ill, and I've been traveling a lot. So I apologize for not doing that. And the request was asking me who all I contacted, and I wasn't able to give that information to him because of confidentiality reasons. I do hear what he's saying, and you know, there's all kinds of things that we can offer up to mitigate his concerns. excuse me, he doesn't want to look at it, I understand that. We could do some kind of a landscape buffer. It's quite far back from the
Chair,
lot.
again, I'm gonna object.
We're almost through the contested case here.
The issue before the commission is regarding the standing, request for granting of standing.
Yeah, why don't we move to a vote, Mr. Chairman?
Thank you, Mr. Chairman. The motion is to grant standing in the contested case hearing to Mr. Nava. With that, we'll take the roll call. Commissioner Henkel,
Aye.
Commissioner Ishibashi,
Aye.
Commissioner Hale Kulani,
No.
Commissioner Moses,
Aye.
Commissioner Ono,
Aye.
and Mr. Chairman. No. The motion passes 4-2.
Okay, and now I believe we need to decide whether we want to hear this ourselves, commissioners, or what's our other option? Have a,
Hearings officer hired.
yeah, what's our financial situation as far as that goes?
A third option is that they could actually appoint, or you could appoint one of the commissioners to preside over the proceedings. So that's an option.
That's option 3.
And regarding funding, if you do decide to hire a hearings officer, we do have a budget for it. So we'll find the money.
Mr. Brown?
Again, the department's position is that, you know, the commission is able to choose any of those three options that has been presented to them from Mr. Jeff Darrow. But I think, again, when I look at a historical perspective, these issues when it comes to granting of cell tower leases have historically been handled in front of the commission. And you know, I haven't been aware of any situation where an actual hearings officer has been assigned to handle these type of matters. So, for the record, the preference would be that we reset this matter for a contested case hearing in front of the full commission and go from there.
I tend to agree with you. But I need a motion from one of my fellow commissioners, please.
I'd like to move that the USE 14-00046 Verizon Wireless application and Mr. Inaba's status as contested case, to have a contested case hearing be heard by the Windward Planning Commission. Is that okay?
Any second?
Second.
Discussion? Commissioners? All right, Mr. Darrow.
Thank you, Mr. Chairman. The motion before us is that this contested case will be heard before the Windward Planning Commission. With that, we'll take the roll. Commissioner Henkel,
Aye.
Commissioner Ishibashi,
Aye.
Commissioner Hale Kulani,
Aye.
Commissioner Moses,
Aye.
Commissioner Ono,
Aye.
and Mr. Chairman.
Aye.
The motion passes 6-0.
So are we gonna pick this up next month? At a future date?
Now, before we get into that too, we also have, leave one
Yes,
person
we're gonna let
who
Mr.
wishes to
Strickland come up.
testify. We do have to set a schedule for the submittal of like statement of position, exhibit witness list. Probably all of that might not be able to be done prior to your next April hearing, so we're probably gonna have to look at probably scheduling it maybe in May or so. So maybe what I could do to help move this thing along is I could work with the individual parties to set that schedule.
Very good. Thank you, Darren. We'll, be in touch. Yeah, Mr. Strickland, though, I would like you to come on up and exercise your right to testify. You've already been sworn in, so just let us know your name, where you live, and go ahead.
Okay, I live in Paradise Drive, Yeah, my name is Lee Strickland, and I live on Paradise Drive. And about a week ago, I was talking to my son-in-law in New York. And we liked the property over in Ainaloa so much, he bought property. It's on Sandalwood. He received information in the mail about it and asked me about it. I knew nothing about it. I'm 2 streets over on Paradise. I received no information. He got information and had to relay it to me from New York on the whole deal. One of my main concerns is, after listening to the testimony today, that this cell tower only has a reach of 2 miles. 1 mile, obviously, on each side, according to their new electrical output or whatever it is. It doesn't go as far as I assumed FM stations would. So one of my concerns was the hazards of human life to being close to those towers. And the lady did mention that it was 2 feet for a prolonged period of time to get damage. I'm not sure of that. You know, that's what that the information was that they got. But I have Verizon service. I went to Verizon service customer because the other one I had wouldn't give me information in my house. It does. I get information from my Verizon phone at my house on Paradise. Someone has mentioned I live in a 2-story house, so I may get a little bit better reception. So down below, some of those streets may not. But you're looking at, the commission is looking at possibility of a lot more towers then. If it's only a 2-mile radius, you're gonna be faced with a lot more of these, it looks like. This tower is really close to a lot of people in Ainaloa. And the lady from Ainaloa, Debbie, gave me the publication out of the paper, and it was, you know, maybe for another tower that's up the road you just talked about. But I guess my main concern, one of them was for visibility. And it looked like this tower, being as that it's close to people, is gonna look like a pine tree, perhaps. I think that's good. I think they have some up on the maybe golf courses here and there, they have those pine tree effect looking things. I think that's good. Let's see. Well, anyway, I'm not too far away from it. I do get cell service, and I'm not so sure about if that cell can't be placed, because I know where that cell service is down there at Shear Foundation. I just did some work for them the other day down there, the big cell tower, and so I'm not sure about being so close to all these people right in there, and I have hesitancy in the sense of knowing how many cell towers are going to go up every 2 miles. So.
Thank you, Mr. Strickland. Does anybody have any questions for the gentleman?
Aesthetically, you're saying that the towers seem to be well, appearance-wise, it looks good, but I'm kind of confused. Are you objecting to this tower, or are you in favor of the tower?
Well, my son-in-law asked me to look into it, and I didn't hear about it. They didn't give me any information, and so I like the idea of it being appealing in the sense of looking like a pine tree, that type of thing. And I understand coverage being out there in Ainaloa. I'm just kind of hesitant in having this thing there next to it, and wondering if it can't be a ways away from more people up there, because there's orchid land, which I have property in also off of Lee Drive, that is bigger lots, humongous lots with less population in them. That's just a little ways away, not very far. So, yeah, I'm kind of hesitant in this thing.
Thank you. Thank you, Mr. Strickland.
Mr. Chairman, I just want to make sure, as you may have noted, the director and deputy corporation counsel of Windward had to leave the proceedings in order to attend to another matter. In their absence, I think, I just want to make sure with the commission if it's okay that you are all right with offering me the ability to work with the parties to schedule the submittal of the various documents and statements needed for the contested case proceedings that hopefully we'll try to shoot for a May hearing.
Fine with me.
Okay, I just wanted to make sure, just recognizing that the director and his attorney is not present, so.
Very good. Okay, so we can move on to item number 3.
I'm sorry, Mr. Chairman. If we could entertain a motion to defer this application until May. Thank you.
Commissioners,
Motion to defer. 14-000046.
Second.
First, can be
very good.
The May hearing is okay, defer to May. And I'm sorry, second, it's
Second was Chairman Ishibashi.
Okay, thank you. With that, we'll take the roll call. Commissioner Henkel,
Aye.
Commissioner Ishibashi,
Aye.
Commissioner Heokulani,
Aye.
Commissioner Moses,
Aye.
Commissioner Ono,
Aye.
and Mr. Chairman.
Aye.
Thank you. The motion passes 6-0.